I'm a U.S. citizen and my husband is on the F1 visa. We got married in 2016 outside the U.S. My husband on the F1 came to the U.S. in 2017 and I came to the U.S. a year later in 2018. First question, how many years of tax returns do we need? The income for 2017 was approximately $17,000. Half from foreign investments and half from working on campus. Could we include his foreign income or not?
Is this to do what? What are they trying to do
when
here?
they're filing their tax returns
For
this
what,
year.
For what purpose are they doing it? They're both on, one is on an F1 visa and one is the spouse of an F1 visa.
Right, is a U.S. citizen spouse.
Oh, it's a U.S. citizen spouse.
Yes.
You have to put all your income from all over the world on your tax returns.
And how many years of tax returns do they need to file the adjustment of status? So they got married in 2016.
Well, they're gonna ask for 3 years taxes, but if you don't have 3 years taxes, it sounds like you're gonna need an affidavit of support from a second person anyway, whether you have the 3 years or not.
All right, our second one comes from Mohammed Youssef saying, hey, sir, I came here as a K-1 visa and got married and applied for my green card and work permit for 2 months before. But my question is, I've passed my driver's license, but the DMV denied to produce the driver's license because they said that I have to show legal residence here. What can I do? I showed them that my green card is pending.
Well, you have to get your work permit. So if you don't get your work permit, motor vehicles is not going to give you the driver's license. That's basically it.
First Lady Hewitt says, okay, this one is not for a friend. My U.S. citizen grandmother filed for my mom in 2013, and my brother was added to that filing because he was under 21 at the time. Now that NVC has sent a mail for payments and so on, but my brother now has a 2-year-old baby. Can we add her to the application, and
No.
if so, how?
No, you don't. You can only go down one generation.
Okay, so
Can't go down 2 generations.
So once brother gets his green card, then he could file for his daughter.
Correct.
All right.
Or he can bring the child if the child is under 2 years old and it's his first entry into America. Then they'll allow him to bring the child.
Now the child is 2 years old.
No, too late.
Damn.
Yeah.
Damn. All right, Sheila Brown says, good afternoon, Brad and crew. My friend is going to get married in May. How early does she have to send the invitations for me to take it to the U.S. Embassy to see if they'll grant me the visa?
Now, if they're getting married in May, it's in a month.
We've got a question from Kavisha who said, Brad, can a stepmother sponsor her stepdaughter? And if so, how can she do it?
As long as the marriage happened before the child turned 18. So if the stepmom married the biological father before the child was 18, you're the stepmom. Then you file an I-130 visa petition.
All right, Pauline Williams says, Brad,
Excuse me.
Is public charge in effect for foreign nationals who are applying or green cards? Also, can you briefly explain public charge or correction who are applying for a green card?
Public charge applies to everyone applying for a green card unless it's asylum or a VAWA. But general green card applications, family-based, employment-based, investment-based, religious worker-based, you have to be above the poverty guidelines. What are the poverty guidelines? Whatever the Department of Health and Human Services says is the minimum poverty guidelines to be above the poverty level in the United States of America on any given year. And not only do you have to be above the poverty level, you got to show that you're 125% above the poverty level unless you're married to somebody who's in the military.
Natasha Baburam said, can I file a VAWA application next week?
Well, right now, Congress is going to be having a vote, the House of Representatives, on VAWA next week. So, or later this week. I think it's actually Wednesday, if my recollection is correct. Then it has to pass the Senate. Then the president has to sign it. So I doubt you'll be able to file it next week, but hopefully in the near term. The biggest issue, by the way, is not the actual VAWA for the immigration. Everybody agrees to that. The Democrats actually are adding additional language onto the VAWA legislation that has nothing to do with the immigration part of VAWA. It has to do with people who are found guilty of domestic abuse, spouses, boyfriends, fathers, uncles, whoever it may be, aunts, whatever it is. It could be a female. They want to bar them from being able to get a gun license. And the Republicans are fighting that. And that's really why VAWA hasn't passed yet.
Amanda Newell says, when they transfer your case to another field office, does the date pick up from the time you filed, or does it start from the date the other field office receives it?
You go to the back of the line of that field office.
Oof.
Oof.
Don Harriet said, can the court rule against your asylum case and then deport you?
Yes, why not?
Can a U.S. citizen's child sponsor his parent 90 days before the child turns 21?
Yes, as long as the I-130 is filed before the child turns 21 and you're a U.S. citizen, that child is under 21 for life. You make sure you get that I-130 filed.
Vanish Beckford is in here asking for a friend. Her friend just filed his adjustment of status, but his affidavit of support was missing. So they denied him, and he explained that they explained that it was because a lack of financial support evidence. So what should he do? Also, they said there was no evidence of inadmission.
You need to refile again. You need to prove that you made a legal entry into America, and you need a good affidavit of support. So you were denied, you got to refile again and get it right. Hopefully get a good lawyer.
A friend came here, and when she came through CPS officer, they have her a no COS, AOS, AOS?
Yes, no change of status, no adjustment of status.
Okay, can she get a judgment of status?
If they wrote no change of status, no adjustment of status, can she get adjustment of status? She could try, actually. I was going to actually make it.
Is it a judgment or is it adjustment?
When she came into the airport, the ICE officer said no change of status, no adjustment of status. But ultimately, that decision is going to be up to the immigration officer when you file your adjustment. So you need a good lawyer.
First Lady Hewitt has a follow-up. She had asked about her brother had a 2-year-old baby, and he was on her filing with mom. You see what I'm saying? So grandma was filing for mom, so brother got on.
Yes,
that
I know,
filing.
but now that's a fourth generation.
And now there's a fourth generation.
You can't do it.
However,
Yeah.
her cousin is in that exact same situation, but the baby is under 2 years old.
Then that baby would be able to come if the baby is brought on the first entry the cousin's coming in.
And do they need to file anything in
You need
particular
to go. You
for
need
that
to go
baby?
bring the baby to the embassy, and you'll give her a document to travel to the United States and wait in the United States for that mother to now file an I-130 visa petition for that child. But the child will be paroled in.
Got it. Nice.
Farid says, my wife's immigration visa refused under Section 212A6CL. What is the solution for this?
I don't know what 212A6C. I haven't memorized the Immigration Nationality Act. So tell me the exact reason why it was denied, and I'll be able to help you.
Material misrepresentation or fraud.
Thank you very
No
much.
problem.
Well, then you need a waiver. She lied.
Bad news bears, y'all. Don't lie to immigration.
Yes, exactly.
Asset Lindo said, what if the marriage took place before the child was 18, but now the child is 26? How long would it take to now file for that child? So
You're talking about,
filing for
then
stepdaughter.
it would be like, the stepmom would be in the shoes of a natural mother, 7 years.
Okay.
I got married to my fiance and we have 2 kids. My husband applied for a green card based on the marriage. Can our children be bona fide relationship, or we have to show more evidence?
Children are bona fide relationship at the time, years ago. You still have to be able to show, let's say your children are 10, 12 years old. All that shows is 10 years ago you had a bona fide relationship. It doesn't mean you have one today. If you have babies, it's a different story.
Dinesh Singh is wondering if someone who has spent more than 2 years in the United States filed for asylum.
Only for changed circumstances. If we talked about it with Abadir on our show, you have to file within the first year unless there's a changed circumstance. The most basic changed circumstance that always comes in my practice, because I have a lot of Jamaican clients, is that a person comes from Jamaica. I see this a lot for Jamaicans at least.
Right.
Person comes from Jamaica. They're here for several years. They then enter into a same-sex relationship or even a same-sex marriage. And for some reason, they don't get their green card through that marriage or that relationship. But now their life's in danger if they go back to Jamaica because their family and everybody found out that they're in a same-sex relationship, and people get, killed and stoned and beat up there, when it's discovered. So that would be a changed circumstance. But you have to show something changed after you got here for 1 year. You just can't say, I was always scared, but now I'm filing 2 years later.